Good afternoon. Welcome to another SERMAPod with SERMA. My name is Brian Rosenblatt. I'm General Counsel for SERMA. It's a pleasure to be here. With me today is Professor James Grimmelmann. He's a professor at Cornell Law School. He has a law degree from Yale. He has an undergraduate from Harvard. It's an easy way to say he's a heck of a lot smarter on the issues we're going to be talking about than I will ever be. Professor Grimmelmann, it's a pleasure to have you with us. Thank you for joining us today.
My pleasure. Glad to be here.
Excellent. So, as a reminder, SERMA is the Sports and Entertainment Risk Management Alliance. It's the first risk management association devoted entirely to the sports and entertainment industries. It's an organization of risk managers, claims managers, general counsels, outside counsel, and other associated professionals who work in sports and entertainment fields. Our mission is to be the world's foremost resource for information and networking in the sports and entertainment risk industries. We strive to provide a respectful, transparent, and inclusive dialogue where members can share ideas, best practices, and strategies in managing risk and claims. With that, we want to dive into a hot topic. We're going to talk about AI, artificial intelligence. We're going to talk about some generative AI. And, in my role as an attorney, I do a lot of intellectual property, a lot of First Amendment rights, freedom of speech. So, anytime a newspaper, to the extent we still have newspapers, files suit, it's always an interesting topic. And we're going to be talking about the New York Times lawsuit against Perplexity AI for allegedly illegal copying of content. James, are you familiar? You're familiar with the complaint, correct?
Yes, I am.
Okay. So the New York Times filed the lawsuit against Perplexity, claiming that the artificial intelligence startup was copying, distributing, displaying millions of its articles without permission to power its generative AI products. This is not the first time Perplexity has come under scrutiny. And we want to talk a little bit about the nature of that case and what it all means, what it means from the legal setting, what it means for everybody else out there. So I guess to start with, can you briefly explain the lawsuit brought by the New York Times against Perplexity AI within the broader context of publisher AI litigation?
Yeah, the lawsuit against Perplexity is a little different from lawsuits that the Times and other publishers have filed against other AI companies, because Perplexity is a little different from other AI companies in what it does. Most of the other AI companies have a general approach that involves training what's called a foundation model, where they ingest a lot of material, use it to create a model, and then put that model out in the world, and it responds to questions and prompts based upon what it's learned from its sources. Perplexity uses an approach called retrieval augmented generation, RAG or RAG, where they have a model, but most of the real magic happens with material the model hasn't explicitly been trained on. Instead, at the time that a user enters in a prompt, the model is able to access Perplexity's database of web pages, or even if needed, go retrieve one on the fly while responding to the user, and analyze that in real time. And the idea behind RAG is that you can get more up-to-date answers if you're constantly refreshing this database. You can go much deeper into the specifics of particular sources. You can have it work with the data that you bring to it or that's on the web, rather than just being confined to whatever the model retained of the data that it was trained on. And the Times' lawsuit focuses on those uses that Perplexity is making, and Perplexity's defense in some ways has been, well, we're different from other AI companies because we don't have as much memorized in our foundation model.
Interesting. Okay, so I know that the lawsuit claims that the startup, their generative AI products created fabricated content and hallucinations. That's one of the many components of that. And it's falsely attributing them to the newspaper. Perplexity has also been accused of scraping data, and it's refuted scraping and instead claims that it's indexing the web pages. I think that's what you just described. How is that different? How is that appropriate?
Yeah. So We'll come back to the hallucination parts and the claims that Perplexity is harming the Times by attributing to it things its reporters didn't say. But as best I can understand it, Perplexity's arguments rest in substantial part on the idea that this is a bit like the user bringing a tool to data the user supplied. And so if I use Microsoft Word to open up a pirated copy of a book and start making edits to it and modifying it, there's a sense in which I'm using Microsoft Word to make an infringing derivative work. But I'm the one who brought the infringing copy into the business to start with. Word is just a tool that's being used that can be used to edit things that I wrote myself, or it can be used to edit and analyze things that are infringing. And Perplexity is, going to make an argument that the user is the one who told us to go find this article and summarize it. And our tool found the Times article and summarized it for them. But they could just as well have told it to summarize something that wasn't a copyright problem. The user is the one who did that. And at least in the copyright space, this isn't an argument that can just be laughed off. There are various cases that indicate that when the user is the one who makes a decision to use particular materials, that the responsibility should perhaps rest with the user rather than with the tool they used to do that. That's arguably what the volitional conduct doctrine says. There are many ways of reading the DMCA 512 safe harbor to say that it's really about putting responsibility where it belongs on the user rather than intermediaries. There is a tradition in copyright law that they can point to that at least cuts in that direction.
So how does anyone or an entity like the New York Times protect either its material, its copyrighted material, or how does it protect a sustainable business model where it licenses access to its material to other entities? And it sounds like Perplexity is bypassing those licenses.
Yeah, so the first stage that the Times would use would just be technical restrictions. That ordinarily web publishers use a robots.txt file or other indications to search engines that they don't want their material to be searchable and publicly accessible. They don't want it to be crawled. And the Times did that, and Perplexity ignores those instructions. It sends its crawlers in to make copies regardless of whether there's a robots.txt file. So then the Times went to the next level of technical measures where they said hard blocked Perplexity's crawler. If a search request came in or a web request came in and it indicated that it was coming from Perplexity, the Times would just ignore it and refuse to send anything back. It appears that Perplexity, therefore, took the obvious step of not saying who it was when it made a lot of these requests, changed what's called the user agent string in the web request. And this is also fairly common practice on the internet, but it means the Times can't tell which queries they're getting are from Perplexity and which ones are from search engines, which ones are from users, and it winds up showing that content to Perplexity that winds up showing it to its users. So if that doesn't work, the Times' next step is litigation, which is what they've gone to.
So just a minute ago, you had mentioned that there's a tradition, there's a colorable argument that it's on the end user who's trying to bypass as opposed to the provider, the tool, as the end user. But this sounds like Perplexity's tool is specifically designed to get around protocols and safety issues.
Yeah, and I think that's a pretty strong argument in favor of the Times, that when you have a tool that is genuinely indifferent between infringing and non-infringing uses, then the argument is at its strongest. But the more that Perplexity does to develop its RAG system to enable this kind of use, and so the more that they take steps to get around the Times' paywall and blocking, or the more that they pre-scrape the internet and have a large archive of this content ready to go to run their system, it looks less and less like non-volitional copying at the direction of a user, and more like something Perplexity itself has done. And at that point, either the volitional conduct or fair use defenses get weaker.
Um, just quickly, tell me the difference between scraping and indexing.
There really isn't much of one. Scraping is the process of gathering data from the web. You send out an automated set of requests to a website or websites, you gather the data. Indexing is one of the things you could do once you have that scraped data. You have to know what the web pages say before you can make an index to them. So scraping is the first step towards indexing, but scraping could also be used as a first step towards making a foundation AI model or towards keeping an archive of the web page for historical purposes. You could scrape for lots of reasons. Making a search engine index is just one of them.
What's the legitimate purpose of an entity like Perplexity keeping an archival copy of a site or a page when that page is readily available?
So to put this in the most charitable perspective for Perplexity, one reason is actually to avoid burdening the Times and others with repeated requests. If you keep your own copy, if you cache it, then you are putting in the effort to avoid sending excessive web requests to their servers. And a lot of websites would appreciate that. They object that AI companies come back too often to scrape their sites and would prefer that the AI companies work from existing caches. A second reason would be that, as many AI companies have argued, if you are training a model, you are doing something that ought to be protected as fair use under the Copyright Act, and you have to build that archive in the first place. Once you have built it, it's wasteful to throw it away. Now, you might want to restrict the uses you put that copy to. This has been one of the issues in litigation against Anthropic. The court there was skeptical of them not putting restrictions on the uses that their copies were put to. But you can see why it would be thought prudent to retain your data, especially if something happens where you might be sued and you have to prove what sources you did and didn't use, or you want to do historical audits of your models or rerun the training run to fix mistakes that you made. There are a lot of reasons to at least keep the archival copy around because it enables you to do better AI development in the future.
You mentioned fair use. You're a professor. You teach copyright to law students. If you were teaching this case in your copyright class, how would you frame the fair use question for your students?
So I would really want to look at the outputs that go to users. And I'd start from there and I'd work backwards towards the beginning of the process. And the Times complaint has a number of cases in which users at the Times were able to get Perplexity to repeat nearly complete introductions to Times articles, entire paragraphs, more direct copying than in any of the other lawsuits they've filed. And that to me looks like a prima facie case of infringement. And in a bunch of
Because
those
it's a
cases,
replacement for the actual original source.
yeah. So
It's one
you
of
are
the four factors.
right. It's one of the four factors. You are going to Perplex instead of the Times' site, which means the Times is losing out on subscription or advertising revenue. And they've told Perplexity not to make the content available in this way. That to me looks like a weak fair use case. But I'd want to know how widespread this practice is. Is it just a few examples the Times was able to come up with? And is this representative, or are in fact most users using Perplexity in this way? I'd want to look at cases where people are using it to summarize Times' articles and produce extracts or new syntheses of them. Fair use is always context dependent, so I'd want to get into that. If I then found that there were a substantial number of uses at the output stage that didn't pass the fair use test, well, then I'd start asking whether the earlier stages are justifiable as fair use. Because I think when it comes to intermediate copies, like the ones you would make when you scrape a website like the Times, they're justifiable if they are inputs into fair use or non-infringing copies. They look less and less justifiable the larger your fraction of outputs that are other infringing.
Is there a Is there a fair use factor that you think would be most compelling in this case? Or which factor would be the most contested?
This is one of these weird cases in which almost every factor is at issue. Um, the transformativeness of RAG and summarization is going to be obviously disputed. Verbatim summarization is different than tell me the most important points or what's the new reporting in this story. Um, the market effects are going to depend a lot on the evidence the Times can bring in about how many users are being diverted, about Perplexity's business model, and the amount copied, as we see, is going to vary from story to story and use to use. So there are actually a lot of factual issues that I don't think we can opine on with great confidence right now.
Would it The amount copied is one of the factors. Is that the amount copied as reflected in the output, or is it the amount copied on the intake side that then generates the output later on? Is that a distinction?
I think it's a quite reasonable distinction, and this is why I think the outputs and the inputs require separate fair use analyses. The outputs are going to depend on how much shows up in what the user sees, but the amount copied at the input stage is obviously much larger. And that's why the input stage is more dependent, I think, on a transformative use analysis, because it's just such wholesale copying that wouldn't fly unless there's a fair use argument involved.
Um, we brought up hallucinations. For our audience that is unfamiliar, tell us what hallucinations are and why they're problematic.
So hallucinations is become the technical term used for AI outputs that make claims about the world that aren't true. Fabricated citations in legal cases, information about football scores that's just wrong or for games that haven't happened yet, anything where it looks like a fact and the fact is just wrong. And this comes up with AI systems that use the deep learning transformer based methods that have come to dominate in the last few years. Because these systems are just stringing together one word after another based on how people use language. It's a minor miracle that they say things that are true at all. And it's proven extremely hard to the point that no one knows how to solve it, how to make these systems work in a way that don't sometimes hallucinate. RAG is an attempt to do that because it's supposed to keep the outputs more closely grounded to specific inputs, and so they won't stray as far from its text. But as the Times' lawsuit illustrates, even in a RAG system like Perplexity, there are still going to be mistakes, like attributing Wirecutter reviews that the Wirecutter never actually published.
I'm familiar with hallucinations in regards to attorneys and ethics opinions. There's a slew of cases right now where attorneys have used AI because I ran out of time, and so they had AI generate a reply brief for a motion for summary judgment. This is the case that comes to mind. And when the judge reviewed that case, he saw citations to cases. None of these citations were cases that actually existed, but the citations included data and information and other citations to more and more and more and more cases, none of which existed. And I know there's a couple of attorneys that are looking at losing their licenses right now because of that. So I understand a problem on that end. And as a lawyer, if I'm signing off on something, I own it. That's on me, and that's my responsibility to protect against that, and ensure that there's a level of accuracy there. When we're talking about a generative or a formulative AI system, at what point does AI Perplexity, at what point do they have liability or responsibility, perhaps? It's not just on their end user, but theirs is the system that's putting out hallucinations and false information. At what point do they have to own that?
So I think this could come up in, I don't know, one of two ways. One of them is where they're producing things that they really should know someone is going to use in a context where the accuracy matters. I don't think Perplexity is in that situation most of the time. Somebody making a specific legal search engine that uses generative AI could be in a situation where they've encouraged the users to pass along its outputs and treat them as trustworthy. I don't think there are a lot of companies that are in that situation yet. We are still in a world where lawyers know or should know that anything generative AI produces may contain hallucinations, and they need to verify citations and quotations themselves. The places where I think Perplexity and others are more exposed is in situations where it's just an ordinary user, but they are used to treating the output of an AI system as useful and correct advice. If people are going to ask, what's the safe dosage of Tylenol? That's the kind of question that it matters a lot to get an accurate answer and not one that's going to cause irreversible liver damage. If people are asking how to do home electrical repairs, proper grounding is one of these things that could mean the difference between physical safety and a catastrophic home fire. And so there are situations in which the AI makers may need to be aware of the stakes of the outputs they're producing. And in those situations, hallucinations can be really dangerous. The Times is coming at this by way of not saying we're concerned about your users getting accurate and inaccurate information, but instead, if you're going to give them inaccurate information, don't pass the buck to us. Don't say this was published in the Times when it wasn't. Like, leave us out of this. Don't make claims using our trademarks, because that's the peg they're hanging it on, that use our Times trademarks to say this false thing is actually from the Times.
I mean, it almost sounds akin to a product liability situation where they're knowingly or indifferently putting something out there that is dangerous.
Yeah, and people have made a lot of proposals to apply something like product liability to AI. It's tricky because in this setting, product liability overlaps, intersects with copyright. It connects to trademark. It goes at all kinds of issues that are not typically addressed through the product liability system. And yet there's something kind of similar about the argument that you put this thing out there, you need to make sure that it's safe when it's used in its ordinary intended use.
Yeah. What so the New York Times is saying, one, you shouldn't be using our protected material in the first place. And then they're saying, two, if you are going to be using it, you sure as hell can't be inaccurately citing to it.
Right.
Is that what this boils down to?
Yeah, that's the copyright claims followed by the trademark claim.
What's do you have an opinion on which side, not necessarily which side is right? Because I think there's argument on both sides, but which side may prevail?
I don't know who's going to win, but I do think that out of the AI companies, Perplexity is the one that has been most willing to fly close to the sun when it comes to legal exposure. They've deliberately done a bunch of things, and you see them in this lawsuit, where they are willing to take on more risk as to how they acquire material and put fewer guardrails on their outputs than a lot of other AI companies have done. And so it's not surprising to me that they are getting lawsuits like this. Now, maybe they'll actually get hit, or maybe this is just a brushback pitch that will make them be more cautious in the future. But I think Perplexity is more meaningfully exposed than a lot of other AI companies.
It doesn't sound to me like it's necessarily a brushback pitch, or at least a brushback that's going to have much impact in terms of making them pause. Um, at at what point or at what level of damages does Perplexity look at it and say, okay, we need to stop doing this because versus our profits are still going to outweigh the expense or even the loss of a lawsuit?
It is hard to say, but when you are playing with copyright and its statutory damages multiplied across large numbers of works, the risks mount up quickly. This is why Anthropic settled for $1.5 billion in an author's class action where they were facing liability, not for their outputs and not for training, but simply for having used material downloaded from infringing sources online as part of their training. And they said, we're going to pay $1.5 billion to get these claims behind us. That's real money.
$1.5 billion is certainly real money. How real is it compared to the profits that they're making?
They're not making any profits right now. None of the AI companies is seriously profitable. They have enormous capital expenses. They have huge valuations, but those valuations are based upon the anticipation of an AI revolution, not on present cash flow.
Okay, so they're betting with somebody else's money, is what we're saying.
Yeah, and so venture capitalists are willing to siphon off $1.5 billion as a way of mitigating the legal risk associated with this huge bet that they're placing. That's a different calculus than an ongoing company with a thriving business that has to pay for it out of present revenue.
Interesting. Interesting. Um, if the Times succeeds on its fundamental claims, what message does that send to other AI companies regarding building the tools and or the citations?
What I think it suggests to other AI companies would be that RAG is not a way of evading the legal issues associated with training AI models. I think there's an emerging set of best practices coming out of the lawsuits against OpenAI, Anthropic, Meta, and Google that suggests you have to do certain things to avoid training on obviously infringing sources, that you need to have certain guardrails in place for your outputs to prevent obvious blatant infringement. Those same rules, I think, transfer over nicely to the RAG context. What Perplexity has been trying to argue is that RAG is at some lower level of risk, and that simply may not be the case.
Um, I took I took copyright and other IP classes when I was in law school, roughly 32 years ago. I learned it as it was at that time, and that snapshot. We see new cases all the time. We see shifts in how protected material is used, certainly over the past 30 years. And then we hear debate and argument about why intellectual property laws or copyright laws have to be changed. And I'm not convinced that copyright law has to change. I think it's more an issue of you just have to operate within the law. That might be me, and that might be my obstinance in not wanting to have to learn a new regime. But do you think that existing copyright frameworks are capable of dealing with generative AI disputes like this? Or are we approaching a point where greater legislative intervention really becomes inevitable?
So I think that judges have a great deal of good common sense in the parts of the copyright system that are able to evolve through common law decision making. And that includes fair use, but it also includes large parts of the definitions of what's copyrightable and some of the exclusive rights where judges have interpreted out short phrases in the Copyright Act into things that work as a functional system. I think the parts of the copyright system that are under the most strain right now are the highly technical definitions, where you have something like the DMCA safe harbor or other rules that are highly tied to the technology that existed at the time when they were passed. And those are places where you can simply get very much out of sync with the times. The legal system moves more slowly than tech does. So we have a several year backlog between developments in AI tech and the litigation over how those work out. But I'm actually fairly confident that when we come out of this in a few years and dust settles, that we will have a reasonably consistent and coherent set of doctrines from the judges who hear those cases. And at that point, it's worth asking, are these doctrines the ones that we want long term, or should Congress step in? But I'm inclined to say let's trust the judges a while longer and give them more time to work through the cases.
We have the mechanisms, we have the framework in place, which just has to be interpreted in a way that works with society.
We have the right institutions.
Excellent, excellent. Any other thoughts?
I'd say this is one of the most interesting times to be a copyright lawyer or a copyright scholar in our entire lives. So it's pretty remarkable to be living through it.
Outstanding. Outstanding. Well, Professor Gribbleman, I want to thank you very, very much for joining us today. This has been extremely informative, and I think it's fascinating. I think that the intricacies and the issues are absolutely, obviously they're at the forefront, but they're just fascinating, and I know they impact everybody in the creative worlds right now. So I think it's been fantastic. I want to thank all of our listeners. And this is another episode of SERMAPod. Thank you very much.